you very much. Good morning, and thank you for this opportunity to share concerns and feedback regarding Bill C-12 on behalf of the International Civil Liberties Monitoring Group, a coalition of 44 Canadian civil society organizations that works to defend civil liberties in the context of national security and anti-terrorism measures. Since the introduction of Bill C-12 and of Bill C-2 before that, we have expressed our urgent concern that this legislation poses a danger to the rights and livelihoods of migrants and refugees in Canada, as well as the privacy rights of nearly all people across the country. As a coalition focused on national security and civil liberties, it may not be apparent why we would speak out over legislation relating to changes in the immigration and refugee system. In our work, though, we have seen time and again how migrants and refugees are used as scapegoats for challenges we face in society, and how quickly and easily they are unjustly framed as national security or public safety threats. We cannot forget that the roots of this legislation is in the follow-up to the $1.3 billion announced in December 2024 to increase surveillance, law enforcement, and other security measures at our border as a response to accusations from the United States that Canada poses a severe security threat to our southern neighbor, despite clear evidence that this simply isn't true. It is unacceptable that Canada would erode fundamental rights or dismantle systems meant to welcome newcomers and protect those fleeing injustice because of trumped-up pressure and manufactured emergencies. Given all this, we believe that Bill C-12 is fundamentally flawed and must be withdrawn. Barring that, there are specific areas of the bill that we believe deserve specific attention. I'm glad to be on this panel with so many esteemed colleagues who will be able to speak to various aspects of Bill C-12. For my part, I would like to speak to two crucial areas. First, we are opposed to the changes in Part 7 of Bill C-12 that would grant Cabinet the extraordinary ability to issue orders to, among other things, suspend or terminate applications for various forms of visas or other immigration documents, as well as to cancel, vary, or suspend existing immigration documents, including temporary visas and permanent residency cards, based on the vague notion of the public interest. Such broad powers, with no safeguards apart from public reporting, are ripe for abuse, particularly given the lack of a specific definition of public interest. Instead, the bill puts forward a non-exhaustive list of areas that fall under the public interest, including administrative errors, fraud, public health, public safety, and national security. Even if we were to believe that the government would limit itself to acting in these areas, they are so broad as to be able to capture nearly any situation. Public safety and national security alone can and have been used by governments to excuse policies that target populations from specific countries or of specific cultural or ethnic background, or that espouse particular political or religious beliefs. Being able to mass cancel the documents of individuals already in the country raises horrendous possibilities of masses of individuals losing status or facing possible deportation based on tenuous allegations of public safety under the guise of protecting the public interest. We may be told that the current government would not use these powers in this manner. That may well be true, but this cannot guarantee that future governments will not. It is difficult to see how such powers can be saved through amendments, and we would recommend that Part 7 be struck from Bill C-12. Second, we are critical of provisions in Part 5 that would expand the ability of Immigration, Refugee, and Citizenship Canada to share private information across federal, provincial, and territorial governments, as well as with foreign entities. These changes would have a significant impact on the privacy of all people in Canada, regardless of status. For migrants and refugees, the powers could inhibit their ability to access critical services without fear or harm, as well as pose serious risks for those fleeing persecution by foreign states. Permanent residents and Canadian citizens could also see their privacy impacted, including the sharing of personal details collected in residency and passport applications. While the categories of what information can be shared may appear narrow, it could in fact be quite revealing and could also be used in ways that would significantly impact an individual's well-being and security far beyond the immigration refugee system. This becomes especially true if information about changes to status, identity, or the refusal, termination, or revocation of documents are shared with law enforcement or other provincial or municipal authorities or foreign entities. Moreover, once information is shared widely, it becomes nearly impossible to control its flow. While Canadian laws may impose restrictions domestically, this is not the case once information is shared internationally. Given all this, and the fact that information disclosure powers already exist at the federal level, we would also argue that Part 5 should simply be removed. Thank you, and I look forward to your questions.